reflected on the flyer, it's going to be a data protection compliance training where we are going to explain to us what we need to know in our capacity as microfinance officials. I'm representing Cyrex Law Firm, and my name is Onyechi Nwachukwu. Just a short brief of me. I'm a lawyer. I'm a lead auditor of ISO 27001, which is a cybersecurity certification. I'm also a lead implementer. I am a certified data protection officer, and I am the lead auditor for Cyrex Law Firm. I have over 17 years of being a lawyer, and specifically, I'm a tech lawyer. I have my working experience from the banking sector to the non-profit and currently fully in cybersecurity. I welcome you all to the call, and I hope we can make the best of the session. And we will have our question and answer at the end of the session. So please, you can jot down whatever you need to clarify at the end. Thank you. So what is data? What is personal data? Can you record the question, please? Sorry?
Hello, ma. Yeah, is the chairman of NAMP training there? Can you record this session for our colleagues that have not yet logged in? Can we record it?
Yes, it's being recorded, but like I said at the beginning, the recording is not exactly intended for the purpose of sharing, just for our records mainly.
You can discuss that later now. Just record first. Let's see how it. Okay.
So I know we already have, when I went through the data protection portal, I noticed several organizations from Anambra chapter already whitelisted, which is something we should be applauding. However, the fact that we can't applaud is the reason we are having this section. And the whole idea is to ensure that beyond being whitelisted, that we understand what it actually means to be whitelisted. We don't just want a situation where it's on the record that, oh, this person is whitelisted. But when it comes to the actual implementation of what it means to be whitelisted, you are not compliant. Now, let me start by saying this. Every audit report has a disclaimer. What does that mean? It means that for every audit report an auditor issues to you, he says one thing: I have approved these people because of what they showed me. What does that imply to you as the organization? It means that if tomorrow something goes wrong in your organization, that auditor will quickly say, I approved them based on what they showed me. I did not see this part, or they did not show me this part, something like that during the audit. So that is why you as the organization, you as the director of any organization, inviting an auditor to your organization to audit you, you need to know what to expect from that auditor. That is the essence of this discussion. I know some of us are quite familiar with some of the things we are going to be saying, but the idea we want to walk away from this session with is to understand what to expect, to understand what the commission expects from you, and to understand how do I get them to have what it is they are expecting from me. So, like I said at the beginning, we are going to just do a general overview, and then we will dive deep into what the Gaid 2025 has to tell us, much more than dealing with theories. We want to be as practical as possible in this session. And then at the end, like I said, we will have a question and answer session. So what is personal data? I'm sure we already know this, so I won't spend much time dealing with these things that I know we are familiar with. Personal data is any data that identifies someone. In your organization, it could be a number. When they say number 5, everybody knows who number 5 is. When they say number 4, everybody knows who number 4 is. And so any information at all that is linked to one person, that the moment that information comes out, it stands out in a way that everybody knows this is the person we are talking about. Sometimes it could be a single information. Sometimes it could be the merger of two informations. I'm sure if I check on this call, I think one of the first persons that joined the call's name was Ebere. That is my sister's name. So if my sister was in this room and I'm trying to ask the Ebere on this call a question, I say, Ebere, the next question that will pop is which one? Or if, let's say, there are two Gladys, I saw a Gladys login on the call. There are two Gladys on the call, and I say, who? Gladys, answer this question. If there was a second Gladys, they'll say which one. I'll need to now add the surname of Gladys to make it vivid who exactly it is I'm referring to. So name, identification number from our BVN to our NIN, which we know can never be shared, to our international passport identity, to our address, to our phone numbers, which, like we know, is never duplicated. Our email addresses also can never be duplicated. Likewise, our biometric information. The moment your thumbprint is taken, it is your thumbprint. Then our religious economic status. The microfinance bank, for instance, if I'm saving my money, they knows how much I have per time. They can see my transaction history. And if for those who have websites and apps, people log in with their devices, the address of that device is seen by that organization. So we have the sensitive ones, we have the non-sensitive ones. And then the sensitive ones are those ones that have far-reaching implication. They are not, most times they are linked to health and other things. But when it comes to the ones that are applicable to microfinance banks, we talk of biometric because, yes, you take my thumbprints. We talk of ethnicity, race. You know where I'm from. You say state of origin, village. We talk of religious opinion. What religion are you? We have all this in our banking opening form. We talk of trade union membership. Yes, you know when someone opens an account under their cooperative, it gives you an idea that, oh, these people are part of this trade union. You also have an idea of people's political views. Those are sensitive. So who are your data subjects? Most times, employees don't remember. I'm sure everyone on this call is an employee. Even if you are the CEO, you were probably hired too, if the bank is not yours. But sometimes, because we are the ones who deal with the data, we don't remember we too are data subjects. And so whenever I talk about data subjects, I always like to start from employees. While you are the one handling the data on behalf of that organization, you too are a data subject. And so it should matter to you what your organization is doing with your data. Sometimes they give you health insurance and then they want to know your blood group, they want to know your genotype, they want to have all those details that are health related, that they may not collect from the customers because they are not a hospital, but they will collect from you because you are their employee. They even do those tests before once you are hired, they'll tell you go for medical screening and bring your results. Sometimes you don't even know what those screening entails. Sometimes they know your HIV status, but they don't tell you. And then the next category of data subjects for a microfinance bank are the customers. Customers who take loans. You know how much they are owing. You know whether they are using the money to build a house or start a new business. You have so much information of them. You know their house address. You have their phone number, their ID card, their picture, their mother's maiden name, a whole lot. And recently, the account opening form for commercial bank has been synchronized to that of microfinance bank, which means that every single thing that used to be collected in the commercial banks that were not usually relevant to the microfinance bank are now being collected. Guarantors also. They say, oh, you want to take loan, bring somebody. The details of that person will be collected. Even vendors. You know, these are some of the data subjects that microfinance banks deal with. And then these data, these subjects enjoy protection right from the Constitution. The Constitution was the first source of protection to data subjects. And Section 37 says the privacy of citizens, their homes, their correspondence, their telephone conversation is guaranteed and protected. And so it is from this provision that the provisions and principles of the Nigerian Data Protection Act is brought from or is empowered from. And then recently in the month of March, I think March 20th this year, the Nigerian Data Protection came up with the latest directive, the General Application and Implementation Directive for the Nigerian Data Protection Act. Some persons may go through the act and they may not be sure what to expect. Initially, there used to be arguments. Am I a major processor? Am I a major controller? But the Gaid 2025 went the extra mile to put all of these confusions to rest. But I'm sure microfinance banks never really had this issue, except for maybe at the point of take-up where they had very few data. So why is this data protection relevant to microfinance banks? Because of the sensitivity of data we collect, like I said before, people's mother's maiden name, their financial record, their biometric, their picture, their home address, everything we want to know under the Know Your Customer rule. And then it is also important because the NDPA 2023 makes the directors of those organizations the ones to be accountable for the provisions of this act. It is not just accountability of this is where I work, this is what I do. However, it goes the extra mile in section 53 to say if there is any breach in your organization, give me a second, let me mute everyone.
Oh,
it wasn't, if you click back there, Uncle Rosemary. Did you touch anything?
Okay.
Please confirm you can hear me. Can we all stay muted, please? Yes. I keep muting us and someone keeps on muting. And when I mute everyone, I mute myself as well. So I said, part of why this is important to microfinance banks
Madam, we can't hear you again. No.
Oh, you are muting me too. If anyone is clicking mute, oh, you will mute me too. Okay. Can you hear me now?
Yes, we can hear you.
If anyone
can hear you,
mute,
we can hear you, my dear.
If anyone clicks mute, or you will mute me too. Okay, so I was explaining that the liability of when a breach occurs will be borne even by the directors personally. There is a current CISO that is in prison. What's really happened in his case? There was a breach in their network, and according to him, the director told him not to escalate or not to report. And so, in line with that directive, he did not escalate, he did not report. And then a second breach occurred on the strength of that first breach. But this time around, the second one was so visible that there was no hiding place. And so the authorities came in. They carried out their investigation and discovered there was a previous breach that wasn't reported. The CISO said, I did not report because the director told me not to report. They asked him, where is the evidence? Unfortunately, he had no evidence, and so he had to go in for it. But if that CISO was careful to just get to his desk and send a mail to say, dear sir, in line with your instructions, I will not be escalating the current breach. If that CISO had brought out such a mail, it would have been the directors of that company who will be in prison today and not that CISO. So this is why it is what important to you that you understand that criminal liability can come upon you if something goes wrong. So if, as a director, you leave the responsibility in the hands of those who should do it, it's a problem. According to the leading practices standards, the involvement of the top management of every organization is key. In ISO, clause 5 has to do with leadership. Leadership determines the body language. Leadership comes in. It's not dispensable. You cannot say, since I don't know it. No, you may not know the technicalities, but you being involved, you asking the right questions, you having it as part of your meeting, you calling the right persons to come in and explain to us during our board meetings. Tell us what's going on. Tell us the update. You taking a look, at least as the executive summary of every audit report, matters. And so you are able to not just safeguard your organization, but safeguard yourself as an individual. Why else does it matter? Because when there's non-compliance, there are legal penalties. Yes. 2% of your last year's revenue, or 2 million, depending on your organization size, or 10 million, or 2% of your last year's revenue, depending on your organization size. And they usually say whichever is higher. So that is something you don't want to just throw away into paying fines or paying damages. And it could be more, because the individuals who are affected can also sue you in their personal capacity to get damages. And then there's reputational damage. The moment the news goes out that, oh, this particular organization had a breach, automatically that organization has its customers saying, no, we can't deal. Please, can we mute? Can we mute? So this is why it matters to you that your organization follows these rules. And then we have the ever-evolving threat landscape. Yes, it's a reality we cannot overemphasize. Prior to this time, I knew when the microfinance banks like the LAPOs that started this business started. It was just people coming to your house or your shops to ask you for money, and then they keep giving you loan, and people will run and hide when they are coming. It was paper, card. They'll say, give me your card. They'll sign for you. They'll go, you go. And then you go to their shops to collect their money, and then you go back to the office. Then I think the major of the problems that the organization, microfinances, used to have then is a staff took money on Friday and didn't show up at work on Monday and never showed up again. And so he ran away with the money he collected or she collected. They go to the person's and say, oh, he packed out on Saturday morning. Oh, and then there were losses of, sometimes they were not healed because not so many customers gave out so much cash at the same time. But that story has changed drastically since the implementation of the platform. Organizations, microfinance banks are no longer business as usual of paper alone. You are now dealing, you are now online, you are now having cloud accounts. People are now transferring money on their own. And as when you are on paper, you are only where you are. But when you are in the cloud, you are everywhere in the world. Anyone from anywhere can access you and do whatever they want. A lot goes wrong. A lot can go wrong. And the list of threats you can deal with, from phishing email, a staff clicking a mail they don't know where it's coming from with a link that they don't understand, to man in the middle attack, the list is endless. I'm sure we heard of when Air Peace had their website cloned, and then people were paying money to an account that didn't belong to Air Peace. That's how bad it can get. The list is endless. I think one of your guys said I should not come and bore you people with cybersecurity talk, but I'm sure we have an understanding of what we are talking about when we say evolving threat landscape. It is endless. So this is part of why it is important for microfinance banks to take data protection seriously. Like I said, I don't want us to begin to beat about the bush. So we are going to use Article 7 of the Gaid 2025 that was launched in March to explain where you come in, to explain what you need to understand. from this whole process. As I read them out, I will keep explaining it to us so we can appreciate it. And then, like I said, at the end, we'll ask questions. So the guide that was launched March 20th, 2025 has this to say in Article 7. General Nigerian Data Protection Act compliance measures by data controllers and data processors. Microfinance banks are both data controllers and data processors. I'm sure we already are aware of that. You are a data controller because you are the one who determines what data is to be collected, what will be done with that data, how it will be collected, how it will be used, etc. And processor is that person who is collecting, who is processing on behalf of the other person. So you may be processing on behalf of another organization. Maybe you have a form of partnership. You too may also have processors under your care. Do you know why this is important to you? Because the law provides that a data controller is vicariously liable for the wrongs of his data processor. What does that mean? If you as an organization calls me to say, come and help us to be opening accounts with your own system in your own house, help us produce the ATM cards, and then my own asset or storage is leaked, and then the data you gave me becomes breached. You who gave me that data as the controller, the person who collected the data, you are guilty of the wrong I have done. So can you see why you cannot just be looking at only yourself? It is a chain of activities. So even if your staff goes and commits a breach, you as the organization, you are also what? Guilty, because on your behalf, they are doing what they are doing. And so the guide is saying, in order to comply with the provisions of the Act, a data controller or processor, amongst others, is expected to do the following. 1, register with NDPC. I've seen several of us in Anambra already registered. So for those who have not registered, registration is required. But that should not be your primary focus. Your primary focus is to put your house in order, because registration entails carrying out audits and all of that. I'll give us an example. An organization called my firm to come and audit them, and we got there, and they said they've already registered. Oh, really? When did you register? They said around November, December. So they want to file their car to meet up with the March 15th deadline. It was March 15th. You know, this new provision came out March 20th. So we said, okay, let's carry out the audit. So we started asking them, upload this, let's see your policies, let's see your processes. It was a whole mess. What the organization did was they just picked one lawyer in their organization and made her the data protection officer. She had no idea what data protection entailed. And so her first step was run to NDPC and register the organization. She did not ask what classification of registry processor or controller were we. She went for the highest. And when we asked her why, she said that is their goal. We intend to be among the highest category. Oh my, it was a disaster. Because at the end of the day, they had nothing running within their system, but they were registered and then they owed to file. So that is why it is part of the compliance first criteria. You need to put your house in order before you run to register. Some of us that are whitelisted, our house is not in order. So don't be just excited that if you open the portal, my name is there. You need to do your homework. You need to get it right. Because even if you get breached while whitelisted, in fact, your problem is double, because it means you lied that, oh, I'm doing it right, when you are not. So that's why I'm emphasizing the need to put what? House in order. Number 2 says, conduct compliance audit within 15 months of commencement of business. This is for those who are new organizations. I'm sure most of us are already are old organizations and don't fall within this category. So if you don't fall within category 2, you then fall within category 3, which says you must conduct and file by not later than 31st of March each year. But there are 3 classes of controllers. There are 3 classes. There is the ultra high, there is the extra high, and then there's the ordinary high. This is subject to the number of data you process. So you need to ask yourself, what number of data am I processing? In the microfinance bank, it means how many employees do I have? How many customers do I have? When you have that data, then you will now know what category you fall into. Why is this important? Because if you are an ordinary processor, you have no business filing car. Yes. This organization I was just talking about, let's go back to it. That organization had just started business. Their entire employees were not even up to 50, yet they went to apply to be ultra high. Ultra high, which is the highest. Then there's extra high. So the only people who need to file annual reports are the ultra high and the extra high. But if you are within the ordinary high, all you need to do is register every year. Every year you go and register. Every year you go and register until your number, your customer base, employee base, your data subject base increases to now take you into the extra high. Now, the fees for each of these categories is also specified in the guide. So, why is this audit important? It is important because you don't want to just have an auditor who comes to your office and tells you, give me this, give me that, give me that, and then they walk away and file for you. And where you wrote no, they help you tick yes. And then you are qualified to be whitelisted. Remember, like I said at the beginning, there is usually a disclaimer on that audit report that says, I made my findings or my conclusions based on what I was shown. So if anything goes wrong, that auditor is saying they did not show me. So the liability falls back on you. So that is why you who calls in an auditor, yes, you cannot audit yourself and file, because auditors, filing must be done only by a designated data protection compliance organization. But you must make sure that what is being done for you aligns with the provision. That is the point I'm emphasizing here. Don't just be excited to say I'm whitelisted. Make sure you are actually white. I don't know if that sentence makes sense. For you to be whitelisted means you are white. So don't be in a hurry to get whitelisted if you are not white. That's the point. So what is the next obligation? It says, identify all your obligations and prepare schedules on how to meet them. So what are some of the obligations? You have to ensure the compliance, integrity, and availability of the data you are collecting. That is what in cybersecurity we call the CIA triad. You have to protect the rights of the data subjects. Some of those rights we already know. Right to access, right to rectification, right to correction, right to erasure, and the list goes on. Then you have to process in line with legal basis. Why am I collecting this data? What am I going to do with it? How long am I going to keep it? Then when you come, those are the principles. Then when you come to the legal basis, lawful basis, legitimate interest or vital interest, contracts, in your case now, it's mostly contract because you are dealing with customers, you are dealing with employees, you are dealing with vendors. So you have a contract with them that makes it necessary for you to have their data. And then we have the DISA, which is the data subject access request. So a customer comes to you and say, I want to see what data you are keeping of me. I want to know the details. The law provides that once that request comes to you, you must respond within 30 days. So if you do not, why is this important? If, for instance, your data is not organized well, and then one customer just cross from the market and say, please, I want to see my account opening form and what is inside. There's something. It means you may need to go to your archives to start searching. I always ask this question. If you go to your nursery or primary school, for those who were probably not privileged to go to nursery school because of our age grade, your primary school today and tell them that you noticed there was a mistake in your result of 1959 and you want them to correct it. Can you imagine how long it will take them to attend to such a request? Can you picture it in your head? That is exactly what and why a responsible data management cycle within your organization is important. I always tell this story. For about 3 years, I lost my status as a lawyer. What happened? The Nigerian Bar Association woke up and said they don't want to be doing paper anymore. They want to go virtual. And so they opened a portal and they asked all the lawyers called to the Nigerian Bar to come and get verified and then start operating on the virtual portal. So I went to get verified, but I couldn't find my name on the portal. I was so heartbroken because I was already in the banking sector. I wasn't like a daily court litigation kind of lawyer. So I was confused. I wasn't sure if, oh, did they remove my name because they've not been seeing me in court? And all the fears of the world came to my mind. I was so broken that I could not tell anyone what was going on. I kept asking myself, was I not at the call to bar? Did I not see myself? You know, every thought ran through my mind. Every year I went back to check when it was time to pay. I could not find my name. Then one day I summoned the courage and I spoke to one of my classmates. I said to him, I've not verified for the past 2 years. I've not found my name on this portal. I don't know what's going on, but I have a call to bar certificate. I know I was in that hall. I know I wrote my exams, I passed. I have my results and everything, but I don't know why my name is on the portal. Is it because I've not been practicing in court? He said, don't worry, I'll go to their office tomorrow. He went to their office the next day, and that was when they discovered what happened. Do you know what happened? They spelled my name wrongly. Instead of O-N-Y-I, they spelled O-N-Y-N-I. And that made it impossible for me to find my name. And I don't know how they set it so that even when I put my surname, my own name did not pop up with those who shared my surname. And that was when they rectified it. But guess what else happened? When my stamp and seal, because that was when they now started issuing stamp and seal, came out, the same error reflected on my stamp, even though it was corrected on the portal. Why was that so? Because of a poor data management cycle system within them. Do you know what? Just this last year, they said they had changed their portal. They are no longer on the old portal. They have opened a new portal. Do you know I went to that portal and experienced the same heartbreak? My name was not on the portal once again. So they used the original database with which they did the first one to do the new one instead of the corrected version. Oh, better this time. I knew who to call, I knew who to speak to, and then I got it rectified. But you see why a responsible data management system saves you trouble. So imagine if it was a situation where I had cause to sue or something. Everything will go wrong. That is how sensitive it is to manage data. Where one person is managing one, another person is managing something else, and then there is that chaos. And then it is important to monitor and maintain security. It's not just to keep the data, you must secure it. I always remember in hospitals where they use manual files. A student will just go into the record room and snap picture and then take one paper out. Imagine if that kind of information is on the street. Or let's say your customer, his loan status is now on the street because your staff was careless with his account information. Sometimes we see staff of organizations wearing their staff t-shirts, making phone calls and giving out information that are sensitive. Why is it so? Because they don't realize the sensitivity of what they are dealing with. You see a bank staff wearing bank t-shirts enter the public bus from his bank's gate, and then he's even issuing a password. Hey, help me log in. Hey, you know my password now. He will start telling. Some of them share their signatures within the banking hall. Then in the commercial bank, it was a rule that nobody should work on your sign-on, but even supervisors worked on people's sign-on and caused problems. Frauds happen because a supervisor is working on someone's sign-on, and then if the person who owns the sign-on is held liable. So this data must be secured, and everyone within the system must understand the sensitivity of what is being dealt with. The greatest cyber security threat found within microfinance banks, especially within Anambra State, based on a research, is insider threat. What does that mean? Your problems come from within you. Your staff member, your team members, your employees are the ones who cause you problem. That's what insider threat means. So either they are giving out information or they are negligent. Sometimes they are even paid by third parties. But what is most important is for you to be able to manage your system. And how do you do that? Through what we call access control. It shouldn't be everything that everybody sees and everybody knows, even the account officer. So these are the strategies that this data protection is calling data controllers and processors to come, do it right, come, get it right. And then now it is important to conduct semi-annual data protection audits. But this one is not going to be done by an outsider, by a DPCO. It has to be done by your DPO. The first requirement for the process is to appoint a DPO. And now with the Gaid 2025, you can't just pick anybody. Or yes, some people think it must be a lawyer. No, it mustn't be a lawyer. Not all lawyers understand data protection. It is a new area. Some people who are not lawyers understand it even better than some lawyers. So you need to appoint your data protection officer, whether you are hiring the person or you are appointing from within, but that person has to be knowledgeable. The new rule says that their certificates will be assessed from time to time annually. So if your data protection officer is just one random person you pick, how will they now be able to conduct audits every 6 months for you? And mind you, this audit report they will produce after the 6 months audit will be part of what you will submit to NDPC at the end of the year during your annual filings. So that is why you need to work with people who understand what it is. So if you are appointing a person and the person doesn't know what to do, you have to train them. You have to train them so that they give you the results that you need and they don't pose a problem. I'll go back to the example I was citing earlier on. We asked the DPO, upload your policies. And this young woman ran to AI and generated policies from everywhere and uploaded for us. But I didn't need to ask her if it was AI, because there are features of a policy that helps you to know whether this policy is a working document of an organization or not. I don't know how many persons are on the call, but I wish someone can tell me what distinguishes the policy of Uzondu, is Uzondu or Uzondu Microfinance Bank from which other bank did I see join the call? From Umuchinemere Microfinance Bank. Can anybody give me a quick answer to that? If you submit your policy to me, don't tell me logo, please. Don't tell me logo, please. Can anybody tell me if you submit your organization's policy to me and the next person submits, how do I distinguish what belongs? What shows me in that document that this policy is actually your organization's policy? Does anybody have an idea?
First and foremost, the bank name.
What?
And location. I say,
first of all,
the bank name. I say the bank name and the location and the state.
And no, I don't. That's why I said, don't tell me logo. I don't want that. I didn't say what shows is your bank. I'm saying what helps me know that this document is actually your organization's document. That you didn't just go to AI to download it and put your bank's name. That's what I'm asking. Does anybody know? Okay, I will explain it. There's something known as the change management or document history provision in every policy. until your management signs and says approved, until that document is reviewed, until it passes through all of these processes, it is not a working document of that organization. At best, it is a draft. So I can come to your bank today, say, oh, we just started business. Please give us your policy. Let's replicate. If I like, I copy everything, including your name. But until the management of my own organization takes it one by one, the first person, me that borrowed it, I've edited it, I've put our logo, I've put our name on the cover page. Yes. The next page is the change management or document history page. There we'll put the version, we'll put the reason we have this policy and all of that. And then it goes through the review. Everybody who reviews it signs with dates. That is what makes it organic to your organization. So if your policy is just your name and your logo and it doesn't have that page, it is not, there's no way you can prove that your management approved it. These are the things the auditor wants to check. It's not just to say we have policy. It's very important. So that is why I was narrating that story to explain to us what is the implications of hiring or appointing someone who lacks knowledge and experience as your data protection officer. And then there's need for internal sensitization and training. That cannot be overemphasized. Because take it or leave it, no matter how careful you are, your team members must come across sensitive information. So they need to be able to know what is sensitive. They need to be able to know how to respect it. They need to know what to do with it. It's very important. So internal sensitization and training of every team member, up to your security, up to your cleaner, is part of the responsibility of the data controller and data processor. Because we often say the weakest link is usually the point where the problem comes in from. So it could be your security. Somebody will give him 50 naira now, and he will say, oh, that pass like this, pass like this. It could be your cleaner. She will see a flash on the floor. I'm going to show us a video at the end of this session. And she'll pick it and say, hey, ma, see who get this flash. And she will insert it in your system, and then you are in trouble. So that is why your training and sensitization must affect everyone and not just your core team members. Then roles and policies, very important. For every responsibility that needs to be done, you need to determine who will be responsible for them, and then you must provide schedules. So sometimes we go for audit and we ask them, show me your schedule, and then they'll pop out one beautiful schedule. Personally, I try to look for the one that the date has elapsed, and then I ask them, did this hold? No. Did this hold? No. So what's the point of having a schedule if you are not going to run with it? So that schedule is a way of ensuring that you set a reminder that beeps to say, next week is for training, next week is for audits, next week is for review, next week is for that just helps you ensure that nothing falls through the crack. And then we already talked about the need to appoint a data protection officer. In addition to a data protection officer, you can have privacy champions. Then in the bank, everybody was a privacy champion because we will tell you this. Anybody sees you doing anything, they'll say, that's non-conformity. That's non-conformity. That's non-conformity. Everybody knows what non-conformity is because we had training every morning. And one team member must be the one to handle training. It mustn't be the supervisor. So in that process, everybody gets used to what is expected and everybody becomes a police officer. You don't need to be caught by the supervisor before you will hear that's non-conformity and then you are expected to adjust yourself. So this is the best approach to actually achieve compliance. Personally, I always say compliance is everybody's business. If you want it to be done by only one person, the data protection officer, you will run into problem. And then the need for policies. I would like to speak more on this issue of policies. Is Uzondu or Uzodu Microfinance Bank on the call? I ran into your organization's website, I think yesterday. Some organizations, including practitioners, think that because the Act uses the word policy interchangeably, that the privacy policy is the same as the privacy notice. It is not. The privacy policy is your internal working document. It is in your privacy policy you are going to outline how you will respond to data subject request, who will be responsible, what depth, the cycle, all of those details, what you expect your staff to do. It shouldn't be in public. It is not for the public. It is an internal working document. It should not be on your website. What you need to have on your website is your privacy notice. Some people still call it privacy policy, but it is actually the privacy policy notice. So even if you decide to tag it policy, fine and good, but the content must be a privacy notice. And what does that mean? It is the notice you are telling the public to say, we respect your privacy. This is the data we collect from you. This is what we will do with it. You cannot come to your website and then you are telling people, our staff will do this, our staff. No, it is wrong. Your privacy notice is that one that pops up once your website is opened. So you have to be speaking to the public and not to your own people within. So please, Uzondu or Uzo, I don't know how to pronounce that name. I observed that on your website. And please, any other organization that has a website, kindly take note of that. It's very important. Because if I'm reading what your staff will do, how is it relevant to me? It doesn't answer what I need to hear as your website or your visitor. So that needs to be corrected. We need to be able to distinguish it, irrespective of the terminology we choose to run with. Then we talk of cookie notice. Whether or not your website is taking cookies, it's safer to put a cookie notice, and it must be such that they must see it. Look at this provision. The last paragraph says, a cookie notice must be displayed in a way that it will obstruct the middle, the left, the right of the home page, so that it will not go unnoticed. So whether you use cookie or not, just put it there. It's safer for you to just have one than not to have. Then the privacy policy, we've already talked about that one, the internal one, then the privacy notice for those coming to you. Then one thing that is also important is at every collection point, there must be a privacy notice. What does that mean? If, for instance, on your website, you have a place where you say, contact us, put a privacy notice there. If you are confused, go to NDPC website, you'll see the sample. For every point, if you have your bank opening form on your website, put a privacy notice there. So every collection point must have that privacy notice. Apart from the general one, it just has to be short, straight to the point. Then ensure transparency. Everything that you want to really be doing must be in that notice. It's not that you say some and you not say some. It must be vivid. What your services are, everything must be stated categorically. Then internal strategy and breach notification. You must develop and circulate an internal data protection strategy or policy. And then a checklist. Directors need to have a checklist. What you will use to check, ask the right questions, know who to talk to, engage with the right team members. Your team members must understand what is going on. Very often we go for audit and then we ask them, have you conducted training? They'll say yes. You go to the security man, Oga, what is your data rights in this organization? He has never heard the word. So you must have that strategy where everybody is working in synergy. Everybody understands what is being done. So the moment somebody comes to your first customer service and is asking for something, even the security man standing next to him knows that is not acceptable. And once you have this strategy and synergy among all your team members, you bridge the gap of one person doing something funny and not being exposed. So it's in your best interest to have that internal strategy that is part of what you add to your trainings. Your privacy policy should be part of what you preach as a sermon during your sessions. Very important. And then you must conduct data protection impact assessments. It's not negotiable. The law provides that whenever you are embarking on a high-risk project, before, for instance, your organizations move from being a paper-based organization to this cloud-based organization, it's at that point you should have conducted a data protection impact assessment. That is a high risk. That is a very high-risk project. So whenever a high-risk project is about to be embarked on, an impact assessment must be done. And then out of that impact assessment, you will then generate your privacy notice to tell the customers who want to participate in that project what the risks are, what you have done to mitigate the risk, what you are going to do in case the risk still occurs, and all of those things. Those are the things that will now be in the privacy notice for that project. But it is not going to be possible if you have not conducted your what? Privacy impact assessment. Privacy impact assessment is one and the same thing with risk assessment. So it's a type of risk assessment. You want to say, what are the things that may happen if we do this? For instance, let's take your moving to the cloud as an example. What are the things that may happen if we move our data to the cloud? I remember that time that project was going on. Many organizations were so slow in their service delivery. Every night, people were working morning, afternoon, night, even weekends. There was the need to learn new skills. Some people who had never touched computer before were now forced to touch computer and work with it by all means. That was when some organizations discovered that their account has not been balancing for the past 2 years because they've been doing it manually. A lot went wrong. So those are the things you will identify ahead before you decide to embark on a project. And so when you identify them, you now plan, how do you manage them? So this is a continuum, especially around the data of the data subjects that you are currently working with or that you will work with. And then once there is a breach, the law provides that within 72 hours of becoming aware, this is very key, of becoming aware, because some organizations have been breached, but they are not aware. But the moment you become aware, your maximum time is 72 hours. But that 72 hours may become too short. If, for instance, you are in Anambra and you are supposed to come and report to NDPC Abuja, so you need to have a strategy in place to help you ensure that you can achieve that. Your 72 hours will be sufficient for you to achieve your goal. It is not only the commission you will notify when there has been a breach. You will also need to tell the data subjects. Why is this important? Because depending on the data that has been breached, the subject may know what to do. I like to give the example of a card data breach. If, for instance, a customer is told, madam, your card data details was breached, that person automatically knows to run and go and block that card. But if the person is not told, the person will keep using the card and the money in that card will be siphoned. So data subjects enjoy some protection when they are notified of such breaches. And then third-party agreements. We work with third party in practically every organization, even if it's that one that brings you water. They come to your premises, they walk into some places. So if you don't have an agreement with them in such a way that ensures that they don't pose a risk to you, you will be the one to be held. Remember, we talked about the vicarious liability principle. You will be the one to be held responsible for their wrongdoings. So that is why it's important to have an agreement with them, especially the ones that have to have direct access to your data. And then we have the data subjects' rights, access and correction. We call it DISA. Give me a second. We call it DISA. So data subjects have the right to say, I want to know what data you have of me. I want to correct it. For instance, you have the data subject of a young woman. She opened her account when she was very young with you. Now she's married. She wants to change her name. She has the right to do so. So you must give her the right to do that and ensure that you have a responsible management cycle that ensures that correction remains the same. So rectification too, they have a right to correction, rectification. They have a right to update. I've changed my address. I'm no longer here. They even have the right to close their account. They have a right of data portability. I don't want to stay with Umuchinemere Microfinance Bank. I want to move to this one. They have that right. Data subjects also have the right to have, like we said, details of whatever it is you are doing with their data, what data you are collecting, why are you collecting it, and then the assurance that you will secure it. The law provides that data subjects have a right to transfer their data with one organization to another. It may not be exactly realistic in maybe a business like the microfinance bank, but it is a right. Let's say, for instance, a customer has left your bank and has moved to another bank, and then they want to maybe carry out what we may call credit bureau checks and all that. Their new bank may want to interface with their old bank to say, oh, can you give us their history? Such a thing is possible, and that's where the right of portability comes in. Then it says that at least within 6 months of commencement of business and at the minimum on an annual basis, personnel of your organizations must be trained on data protection laws and practices. And then finally, data subjects must know how to complain. The law provides that you must provide a contact detail exclusive for the data protection officer of your organization. Sorry, Uzo, I will refer to you again. I observed in your policy, in your privacy policy, you had a specific contact detail for your data protection officer. But when you went to your privacy notice, you had a different one. It must be exclusive and it must be uniform. So you must have that. If it's an email, DPO at your organization's name. If it's a phone number, that phone number must be, that call that comes in must be picked by the data protection officer, not somebody who will say, okay, wait, let me go and give her. So there must be that designated contact, and it must be publicly displayed on your communication, either your website or however or your forms, maybe your account opening forms and all of those things. Even on your transaction tellers, it's still okay if for those who probably don't have websites yet. But if you have an online presence, you must display a dedicated contact for your data protection officer. And then that page, that home page where you talk about all those privacy notice and all that, must state to data subjects how they can complain. I want to rectify. How do I go about it? If I can open an account on your portal, I should be able to initiate a rectification on your portal as well. So you need to tell me step by step, like we see on the screen, step 1, step 2, step 3, step 4, how to go about it. It must be very clear for everyone to understand, okay, these people are really serious about letting data subjects enjoy their rights. So I think I've been able to hit most of the core obligations, especially as seen in Article 7 of the Gaid 2025. I'm open to questions. If anybody has any questions, we can discuss at this point. Thank you.
Hello, good morning, moderator.
Okay, before we start our questions, can I quickly play the video I was talking about?
Please, I want to ask a question.
Yes, you can
Give me
play
a
the video
second.
now.
Yes, let me play the video before we start our question and answer session. So we'll just round off from there.
Yes, yeah.
Okay, the first person who wants to ask a question can start while I'm putting the video on.
Okay, good morning, the moderator.
Good morning.
Please, can we get a number that for inquiry? Phone number.
Sorry, I don't get your question.
Please, I mean, can we get your phone number so that I can get to you and maybe get more about this training?
Okay. Sorry, who is speaking? I'm sorry, I'm trying to find the speaker.
Okay, please. I'm speaking from Mokola Microfinance Bank.
Okay.
Anambra State.
Okay. I'll need to liaise with your association leads on how best they will want that to be done. I don't know if they are comfortable with that, so it's fine. I'll speak to them, and then I'm sure they invited you to the session.
Yeah.
So I think we can have that discussion. Okay, now let me play the video I wanted to play before the next question. Please give me a second. Did we get it this time?
Yes, ma'am.
Yes.
Yes, ma'am.
Good.
Yes.
Good. So the point of that video is that, like I was saying, ever-evolving threat landscape. You see a flash drive, your cleaner sees a flash drive on the floor. Say, hey, now Mark, they usually they see where they hold this kind of flash drive, or make I go give them, it go be on. And then before you know, your systems are all corrupted. So that is how sensitive and dangerous at the same time all of these can get. Are we together? So that is why data protection is serious business. Imagine all the things that can be done with this information. Kidnapping is very common today, mostly because people from the banking industry are the ones giving out some of the account balance of the victims. Yes. So that is why it is a serious business to protect the data within your care. Can we have people who want to ask questions raise their hands? Okay, Okuzu Microfinance Bank, please go ahead.
Okay, I don't really have a question, but I just want to know if we can get the slide of this training, maybe in our emails or through the Anambra NAM chapter. Is it possible?
Did
you get my? Did you hear me?
Yes, I heard you. That depends on your leadership too.
End of.
But that would be necessary. And some of us didn't start on, and because of the network.
It's the bank or the external person bank higher.
Okay. Show Uncle, please go ahead.
Chico.
To make a request, but
sure, Uncle, please go ahead.
I said I needed to make a request on the slide, but Okuzu Microfinance Bank already did. Thank you.
Okay. Is there anyone who has any other question?
Yes, sir.
So go ahead, please.
Hello.
Go ahead.
Hello.
Please, how can we get the slide?
Please, nobody should ask any questions about slides. I've given a general response. The general response is, I'll liaise with your executive. I cannot answer questions as regards your modus operandi. So they will be the one to deal with that. Let's have questions as regards what we discussed, please. Mr. Geoffrey, please go ahead.
Okay, madam, good morning.
Good morning, sir.
Mr. Geoffrey is the chairman of Anambra State.
I'm aware, sir.
Okay. So, in respect of getting the slides, you have given the appropriate answer. So we will liaise with you and then communicate to them. So they should go ahead and ask whatever necessary question they have. The slides issue will be sorted out with you. Thank you.
Thank you, sir. Sure, Uncle, I think you already commented on what you wanted to comment. So if you are done, can you put your hand down? Mesoma, did I see your hand up? Mesoma.
Yeah, good afternoon, ma.
Good morning. Good afternoon.
Ma, please, I would like more clarification or more emphasis on the cookie when you were talking about the privacy policy and the privacy notice. You made mention of the cookie aspect. I didn't really understand that cookie aspect. That one.
Okay.
Like the
Cookies
importance.
refers. Okay. Are you done?
Yes, ma. Yes, ma.
Okay, what is cookie? Cookie refers to the fact that you have plugins on your website. I'm sure maybe you've gone to a website today to browse about buying a new shoe or a new phone. Every other website you visit throughout that day, they will keep advertising that new shoe or that new phone to you. Why is that possible? Because that website you went to browse about that shoe or phone has a cookie. What does it do? It tracks every page you opened on the website. And then it begins to give you things related to it. The same thing happens practically on every website. If you've gone to YouTube to watch a movie, the next time you log in, they'll start suggesting. Even our Netflix accounts, next suggestion for you, next suggestion for you. What are they doing? They are giving you suggestions based on what you have done. So every organization needs to notify customers coming to their websites that we use cookies, meaning for every page you open on our website, we will take a history of it. And on the strength of that, those cookies are mostly sold to other websites, to third parties, who will now be the one using that information to now advertise to you. So you need to tell those customers that we use cookie on our website. But like I was saying, even if you don't use cookie, it is better to put a cookie notice to say, we may take your cookie. Why is that necessary? Because your website may not be taking cookie today, but the person who will do who will do an update may decide to put a cookie for you without even asking you. But if you already have a standing notice there, you are now covered to say you did not take you did not track the person's online activities without notifying them. Do you understand that? Is it well explained?
Because everyone moved to
Miss Oma, did you get the point?
Many people they cook now.
Yes, ma. Yes, ma. I got you. Thank you, ma.
Good. Sure, Uncle, your hands are still up. Do you still have another question, or is the one you raised before?
I think it's the one I raised before, but I have another question, please.
Okay, go ahead.
You said something about using the phrase non-conformity. I think
Yes.
I want to understand, how do you communicate that, and what does it really like? Is it among the staff? I didn't get that part. My network broke. Can you explain the
Non-conformity or non-compliance means you are not doing what the policy says. So if everybody in your organization now understands what the policy says, it then means that if you like go into the toilet, female toilet, to hide, to do something, maybe your policy says no answering of personal phone calls within the banking premises. And then the person says, after all, supervisor and a man, he won't be in the female toilet. And then that person runs into the female toilet to answer that phone call. It is a fellow female staff that will see the person and say, oh, this is non-compliance or this is non-conformity. Non-conformity is used when it has to do with a policy that is not mandatory. This is a bit more technical. And then non-compliance has to do with when it has to do with a law. For instance, the NDPA is a law, so it has to do with non-compliance. So what we are saying is everybody in your team must be a compliance officer. It doesn't have to be only the supervisor or the data protection officer that will be finding out that somebody is doing something wrong. Everybody must be a watchdog to say, this is wrong, this is wrong, this is wrong. To call the attention of the person who is doing something wrong to say, you are doing something wrong. Do you understand what we are saying? We say compliance is everybody's business. But if I don't know the rule, how will I now say no or say that somebody is doing something wrong? That's the point I was making when I said that. I hope you get the point. You're welcome.
Thank you.
Mr. Emmanuel, please go ahead.
Yeah, good afternoon.
Good afternoon.
My question is, when you were making your presentation, you made a statement that it is an organization can choose to engage external person as their DPO, which for long we have been hearing that a DPO is supposed to come within. So I want you to expatiate on that.
You can advertise to hire a DPO. So you would put your qualifications on the list. Vacancy for DPO. This DPO must be someone who studied any course or law, if you are insisting on law, must have so and so certification, must have so and so year of experience. There's nothing wrong with hiring someone just for that role. There's no rule that says you must appoint. If nobody within your organization has sufficient experience to be able to handle the role, you are better safe than sorry. There's nothing wrong with hiring a DPO just for that position.
We may appoint madam from the office because I'm not my point. I'm already the experience.
Do you understand what I'm saying, Mr. Emmanuel?
Yes, I understand. But what I'm saying is,
Mr. Emmanuel, please unmute yourself again. I was trying to mute the person that was speaking.
okay. What I'm saying is, can an organization cover up that role, or must it be an individual? Because that's the side I'm coming from. If an organization can take up that responsibility.
Okay. If you want to hire an organization to be your provide data protection as a service.
Exactly, that's what I'm saying.
Oh yes, more and more law firms are going into that, and it's allowed. There's nothing wrong with that. As long as you have a working relationship, you know how many times the person will come, either quarterly, weekly, whatever. It is possible. In fact, many organizations are opting for that because it's a bit cheaper. And then it saves you from trouble instead of just picking anybody that doesn't know what they are doing. Yes, it's very okay as long as you have a contract of engagement.
Okay, thank you.
You're welcome. Do we have any other question? Ndiora Microfinance Bank, please go ahead. Ndiora, please unmute your mic to speak. Ndiora, we are waiting for you. Oka Etiti, please, we need you to stay muted. Ndiora, do you have a problem with unmuting your mic? Okay, while we are trying to get in, okay. Ndiora, go ahead. You are raising your hand. Go ahead. Okay, do we have any other person who has a question while we are waiting for Ndiora to sort his mic out? If you want to put your question in the chat, it's also okay.
Ever get here.
Chidozie, please go ahead.
Okay, thank you, ma. Hello. Hello, ma. Can you hear me?
Yes, please go ahead. I can hear you.
Okay, you made mention of a director asking the DPO or something not to escalate a breach. What if the director gave such direction verbally, and the DPO or the staff needed to be official, yeah, it to be evidential? How do you go about it?
Please repeat yourself. I didn't hear the last part of your question. If he gave it verbally, then what?
You made mention of a director asking a DPO not to escalate a breach. Then my question is, what if the director made that direction, give that instruction verbally, that is on a physical face-to-face discussion? How then does the DPO make the instruction official in terms of
That was
when?
why I said, yeah, that was why I said what that person would have done is to go to his seat and send a mail. Yes, sir, in line with your verbal instruction to not escalate. I'm acknowledging that I've heard this. It's just being strategic to safeguard yourself. Do you understand?
Okay, thank you.
Yes, yes.
Oh, yes.
Depending on what the communication structure in your organization is, you just do something to make sure that you have a documentation of that verbal instruction. Or you can tell him, sir, please, can you put it in writing? I know it's a bit difficult in our climate, but it's also an option. Did you get that, Chidose?
But madam.
Yes, thank you.
Madam, please, when director refuses to put it in writing, or what can you do?
And that's why you will be the one to send the mail. Dear sir, in line with the instruction you have given, I am acknowledging receipts and acknowledging that I have complied accordingly. But you know that if you've told him to put it in writing before doing that, he may know that you are trying to be smart. So the safest way might not just be to don't ask him to put it in writing. If you've not had that culture in the past, you just be the one to put it in writing and acknowledge receipt of it. Is that okay? The whole idea is to shield yourself from being personally liable if you are just acting on an instruction. That's just it. So whatever strategy works for you is the whole idea around that point. Maduka, please go ahead. Maduka Ijoma Ichi. Unmute yourself to speak, please. Maduka, can you please unmute yourself to speak? You can drop your question in the chat box. Is there anyone else who has any question? Okay, show Anchor, please go ahead.
Yeah, thank you. on the level of data controllers, I think you mentioned ultra high, extra high, ordinary high, and normal high.
Mhm.
My-
Yes. Yes.
Okay, now, okay, so the normal high is the organization with the that is the lowest data controllers, right?
What did you say?
The normal high is the lowest.
Not
That is in
normal,
that in
ordinary. Ordinary.
okay, ordinary. So okay,
Yes.
that is I want to know the lowest between ordinary. There's no normal, right?
No, there's nothing like normal. There's ordinary, extra, and ultra.
Okay. Ordinary is the lowest in terms
Yes.
of data. Okay.
Yes,
All
and
right.
they are not required to carry out audits, just to register every year.
Okay. And it's also determined by the number of employees, right?
No, the number of data being processed.
Okay, just
which
data.
includes both your employees and your customers.
Okay.
Your
All
vendors,
right.
every data subject. You need to know who your data subjects are. Some organizations don't know who their data subjects are. If you don't map your data subjects correctly, you will run into problems with knowing the correct number of data you process. So you need to map your data correctly.
Okay. All right. Thank you.
Okay, so Chibike, you are asking how do you get the guide for the data protection compliance? It's on the NDPC website. It's a public document, but it's usually used by mostly the the DPCOs, the auditors. And that document contains the questions that are asked during the audit section. So if you have that document, you are able to now use it to conduct even your mid-year audit for yourself instead of just doing anything that comes to your mind. I hope that point I'm making is understood. So I'm saying the guide contains the templates for carrying out the audits. So if you want to audit yourself, you can use it as your guide. Ask yourself those questions and answer them, but you need to understand what each of those questions mean, because that's where the problem is. Even some DPCOs don't totally understand what those questions mean. So you need to make sure that you understand the questions, what they mean, for you to be able to respond correctly, and then make sure that you are answering correctly and doing the right thing. Okay.
Hello?
Elias. Hello? Yes, please.
Hello?
Yes, go ahead.
Samuel.
Okay, Samuel, go ahead.
Are you listening? Samuel from Ichi Microfinance Bank.
Go ahead with your question.
My question is concerning the yearly or semi-annual returns on this data protection report. Is it to be done by the bank or the independent experts hired by the bank?
No.
Hello?
The semi annual audits, not returns,
Yes.
please.
Okay,
the semi-annual audit is to be done by your data protection officer.
Okay.
Yes, and it's not to be filed until the annual audit, which will be submitted to the DPCO, the external one, who will add it to the report that will be uploaded when filing your annual reports.
Okay.
Do you get that?
Yes.
So Elias Okoro is asking, please, what are the conditions that qualifies you to register your organization in terms of employee strength, customer base, and data in the various categories? I mean the exact number. Okay. I wouldn't like to guess that number. Let me open it. It's in the guide. It's in the guide. Article 10 specifically gives an outline of the various numbers. But let me open it and read it out so I don't give you the wrong figure. But it's important for everyone to download a copy of this guide. I don't know if I should paste it on the chat box. If I paste it on the chat box, can you people download it? If I paste it on the chat box of this call, can you download it?
We'll try. Yes,
Let me
yes,
just paste it first. We'll try. First, at least those that can do it can send to others.
Okay, good. It's a public document. That's why I'm not asking your leadership before asking if I can paste it for you people. Oh, I can't seem to see an option on how to paste it. Okay, don't worry. I'll share it with your leadership. I'm sure they can be able to send it across to you. I can't find.
I'm not sending it.
Or should we drop our emails?
No, it will make the chat box clumsy. Whatever I'm giving to you can go through your leadership. Okay, it's fine. Okay. I can't see an option for document, just apps. Okay, so I was going to read the provision. Okay. Who asked the question, please? Elias.
Is the Elias Okoro?
Yes, Elias, I'm going to read it for you.
Please. Ma.
Yes, please.
Please, it's raining down here. We can't hear you very well.
What did you say?
I said we can't hear you very well. It's raining here.
That's one is your business now.
No, what he's saying
okay,
is
so I'm sharing the guide on my screen now. It's a 117 pages document, but it has just 52 articles in it. I'm scrolling down to the article 10 that gives an outline of the numbers. But like I said before, it also contains this is what the criteria. Please, can we mute? Okay. If you are speaking and your voice is louder than my own, it confuses my head.
copy.
Okay. Okay, so this is the criteria for assessment of who you hire as a DPO. This is on page 81, schedule 3. The person must have a certificate. Remember, like I said, it will be assessed every year. The person must be going for training. So you see why you need this document. Even if you want to hire an organization, you want to make sure they meet up with these criteria, that you don't just hire anybody. Then this one is the data, how to conduct the data impact assessment if you are embarking on a high-risk project. So if you have a copy of this guide, you practically have everything you need to actually know what to do per time. This lawful basis rated here, necessity and proportionality. Even business continuity has been added now to the requirements. How do you continue your business if you suffer a breach, or will you shut down your doors and go home and say till further notice? All of these are included on the requirements now for you to file and all of that. I'm trying to scroll down to the schedule 10 where we have that number, so I'll read it out to you. It also reflects the new rates. So for those who are going to register or by faith that they will join the ultra, you will be paying for the ultra filing rate for in line with your faith. So this is it on my screen, schedule 10. Ultra high has each of them has three classes. A is 50,000 data and above. Your filing fee will now become 1 million naira. So let's say extra high is 10,000. You now say by faith you want to join ultra high. you will now be paying 1 million naira instead of 250. Does it make business sense? It doesn't. So you see why you need to make sure that you are hiring a data protection officer that knows what they are doing. Imagine that girl now. Her organization is still in ordinary high. So they are not even supposed to be filing, but she went to register them as ultra high by faith that that's where they are going to 50,000. Meanwhile, they've not, even their staff, it's not up to 50. So you see why this is important. So now under the ultra high class, category A is 50,000 and above, filing fee 1 million. Category B is 25,000 to 49,999. Filing fee is 750. Category C is below 25,000. Filing fee 500,000. Extra high is 10,000 and above. Filing fee 250. Category B 5,000 to 2,500. Filing fee 200,000. Extra high is category C is below 2,500. Filing fee is 100,000. Remember that this is the fee you are paying to NDPCO. That's why I said this document is actually for the Data Protection Compliance Organization. That compliance organization that is going to audit you will definitely have their own fee for auditing you in addition to this official fee. So it's not that you go and meet a DPCO and say, after all, I'm extra high, my fee is 100,000. No, they will have to add their own professional fee to whatever services they are rendering for you. But if you meet an auditor that say, yeah, bring 50,000 and they don't audit you, they want to whitelist you, you are being deceived, because the day the problem will start, they will escape it with that disclaimer on the audit report. So I hope I've been able to answer your question, Mr. Elias.
Yes, thank you very much.
You're welcome. Do we have any other question? We are almost 30 minutes beyond the agreed time, but I know we didn't start at the exact take-off time. No, I can't copy and paste it. It's a PDF document. Should the bank decide to appoint who has no experience? Oh yes, the bank has, in DORA, the bank has a responsibility to appoint anybody who has no experience, but must train them accordingly. That is the requirement. So, and if you are training, you want to make sure that you are training with someone who can train them on all the relevant aspects of what they need to know. Like I always say, if you know what you'll be audited on, then you know how to implement. So if you go to, let's say, DPCO to train, who knows what they are auditing? Because that is the problem we are seeing now. Some DPCOs just got the privilege of getting licensed, but they don't seem to understand what it is they are auditing. So yes, you have the responsibility to train such a person, and it's fine. It's up to you. It's at your expense. But don't appoint somebody and then give them a responsibility without empowering them to do the work. Are we good? Are we good? Are we good? Any other question? Any other question?
No.
Akuzu, you want to speak?
No.
Okay.
I just wanted to respond that there's no other questions.
Okay, sure, Anchor. Yes, ordinary high data controllers are not expected to file annual reports. They are expected to register every year. So they will keep registering and keep registering and keep registering until their grade increases. But they don't file the compliance annual report. I saw a hand up. How do you know the number of subjects? Yes, your customer, we said that at the beginning, Pentecost. Your customers, your employees, your vendors, your contractors, they are all part of your data subject. That's why I said it's important for you to know how to map your data subject so you don't make a mistake in your numbering and say, no, we are ordinary high when you're actually extra high. You must understand who your data subjects are and be able to calculate correctly. You're welcome. Somebody's hand was up. I missed that name. Okay. If the person change their mind or they want to drop it, their message, okay. No, I'm not taking your emails. We already said that. Every other further discussions will be in line with your leadership. I'm not taking emails. Okay. Thank you all for being on the call. I appreciate your presence here, and I hope the time here was worth it. I hope you've been able to get something new, and you were able to pick up or understand anything you knew before a little better. Like we always say, you must learn, relearn, and unlearn. So the slides and the contact details of my organization can be shared through your leadership to all of you, and then we can have any other further discussions if anybody needs to. Thank you also once again, and Mr. Geoffrey, thank you so much for making this possible. If you want to give any closing remarks, the floor is yours.
Okay, madam, good afternoon. We appreciate what you have done so far. I think that the rest of the burden in the evening. You have done a very good job, and I promise we'll be working with you. So when we go back to our ESCO meeting, we'll be able to discuss fully on the modality. But we expect that you will send the slide, go through the capacity building committee just to intimate me. So I thank you so much for what you have done. You have opened our eyes better than what we know before. And all the participants that attended, we thank all of you for. And once more, we say a very big thank you. We'll be working with you. Thank you very much.
Thank you so much, sir. I'm very grateful. I look forward to hearing from you and everyone on the call. All the best and enjoy the rest of your day. And I pray that you all will remain compliant. Enjoy your day. Bye then.
Thank you.
Can we get your number, man?
Thank you.